Welcome to another episode of The Velvet Hammer.
And here we go.
Voir dire.
To speak the truth.
We've had a lot of people ask us to talk about this.
Yeah, we've been getting a lot of, not even just lawyers, but like lay people.
Yeah.
They want to know, what the heck is it?
What is voir dire?
Yeah. What is?
It's
I mean, I can tell it from mine because I've been on a jury, and from my perspective, voir dire is the attorneys asking questions of the potential jurors and deciding how it will help or hurt their case, and then they get the opportunity to remove some of those people. So it's kind of a little bit of a chess game on figuring out who's going to be on the jury and not.
Yeah, the word actually means to speak the truth, and it's like a process. It's traditionally meant to be a process of identifying fair and impartial jurors that will decide the case. Historically, it was conducted by the judge, but only in more recent times have lawyers been conducting it. But it's different in many respects, has differences and nuances.
Some people say it's the most important part of a case. And for me, I've always loved voir dire, which is very unusual. Like, most attorneys hate it. And we can talk about why. Yeah. Why most attorneys hate it. But for me, it's like the absolute most jousting part of the case. Right at the beginning. Super high stakes, super gamey. Everybody's playing a game and a role. And it is just wild. It's like wild.
Well, it is. It's very interesting because, there's sometimes 100 or more people there.
700 were called for Ride the Ducks.
Yeah, so for a big case, there's even more than that. And
400 showed up.
And what's crazy is a bunch of those can get cut out almost immediately.
Yes, yeah. So we'll go through that process, but it is, when I say gamey, it is the rules. There are no rules. I mean, there's court rules. You have to follow the court rules. But it's all the subliminal stuff that is going on. And a lot of people that can afford it, i.e. the defendants, will have their jury consultants in there.
Yeah.
Sometimes the plaintiff will have it, but often there will be these jury consultants. In the Ride the Ducks case, teams of jury consultants. Like, there were so many of them. And you can hardly walk around the courtroom without stepping on one. Just super interesting. And then now we've gone from in-person voir dire, at least in King County, to only Zoom voir dire. Smaller jurisdictions around the state, still in person. But what's it like to have Zoom voir dire? So this is going to be a multi-part series on voir dire. This will be part number 1. And let's just start kind of like with a story. And we're gonna really kind of start at the very beginning of the difference between criminal and civil and voir dire.
The criminal voir dire, I've been involved in voir dire where we do single juror voir dires.
By the way, is it voir dire or voir dire?
Voir dire. I think.
Or voir dire?
No, it's
Latin, right?
It's Anglo-French.
Anglo-French.
Voir dire.
Voir dire.
Voir dire.
But down in,
That's what I was going to say. That's down in the South.
That's maybe in Louisiana, they voir dire.
You're saying it wrong. It's voir dire.
Fire. Well, in the South, they say fire, they go fire. They don't say fire, they go fire. So it's like voir dire.
Okay, enough of that. Get back on track.
Okay. So there have been cases I've been on where we do single juror voir dire because the case is so sensitive that you spend time with an individual juror. And in criminal cases, that usually involves cases involving, sexual assault, and you're going to ask jurors about their private experiences. So you want to give them a space of privacy.
By the way, even before this, like, there are differences. There's some states where there is no such thing as civil voir dire. Mm-hmm. And then we have the difference between federal court voir dire and real voir dire in state court. Federal voir dire in a civil case is very constrained and horrible, in my opinion.
It is? Yeah. In criminal,
horrible.
In criminal, what you're doing is you're trying to see if the jury is going to apply the burden of proof. They're not going to think about the Fifth Amendment. If my client doesn't take the stand, what are your thoughts on that? Somewhat straightforward stuff. And so the conversations is about their perspectives on safety, on victims, on police, on law enforcement. You know, generally speaking, historically, police reviewed very favorably. So, some of the questioning would have to do you think that a police officer should receive some imprimatur of credibility above another witness? Oh, yeah, he's a police officer.
Would you say imprimatur to a jury?
I didn't say imprimatur.
Because why wouldn't you say that word to a jury?
Because that's crazy. They would be like, what are you saying?
Right. So how do you speak to a
I would
jury?
just be like, do you believe cops more than you believe normal people, like regular people?
Yeah.
You have this sort of
Do
conversation.
you use a lot of legal words?
No. They're lawyer. For some reason, a lot of prosecutors are
Stuck up?
I don't know. They're not stuck up. They do this style which is close-ended questioning. They go, "Will you promise to be fair and impartial?"
Leading question.
Yeah, like basically leading question. Will you promise to be fair? I'm like, what is this really doing? Who's going to say no? I'm not going to be fair and impartial. I'm going to be biased. But sometimes you get the people who really want to off the jury.
Because they're the government, and the government is dictatorial sometimes.
Sometimes, but also in criminal, it's important. I think it's important in civil. It's the first opportunity the jury gets a chance to get to
Stay
know
off
you.
my side of the lane.
Is that they get to know you. They get to see who you are.
Yes.
And and so
It's your first date.
yeah. So the way I kind of break the ice, I walk in and I just say, "Hi, I'm Mo. I'm one of the lawyers, and I represent my client." How many of you, when you walked in here today, just by the sheer fact that my client is sitting over here and is accused of a crime, start to think if he's guilty or not? How many of you did it? Come on, be honest. Be honest. And then people would start raising their hand and be like, "Well, why'd you do that?" And then they would say, "Well, if the person's here, we're in federal court, and we're in this, something must have happened. Why are we here?" And then I go, how many of you would say that is bias?
See, I was going to say you're kind of talking to him.
Right,
You're leading
bias.
him into talking about bias.
I'm biased. And then I go, how many people agree that that's bias? And then so
Yeah.
those are once they raise their hands, I go, I have like somebody taking notes, and I'm like, everybody, okay, they understand that kind of thinking is bias. So I like those people. I don't go after them, right? And then I go, who thinks that that's not bias? And they're like, that's not bias, And then I go backwards. I try to deselect. So I try to find my bad jurors and try to deselect as many as possible. But, it's not like closed box questioning, which is like you just get to question the box. Judge brings the jurors in, puts 12 in the box, and then everybody's sitting in the courtroom. You questioned an entire courtroom. So you're not just focusing on the box.
Okay, hold on.
Yeah.
So what was the assignment of the first question that I asked you?
You're asking me about criminal. I'm telling you what a criminal body. I'm telling you what I do.
But just like the differences between criminal and civil. So
You told me to stay away from the civil.
I know. I'm gonna do the civil.
Okay, I'm done.
But let's just keep it shorter because we're gonna break this up. We can't.
Okay.
There's so many different pieces to voir dire.
It's true. And I've done that. Like that's when I was
Yeah.
in my last jury, that was what it was like in the box. But they were addressing everyone. And and people were getting cut out from the box, but then they would move somebody in. And so it was constantly the 12 people, but they were still sort of, it was like who got moved in first was who they were trying to decide was getting off or not then.
Yeah. Okay, so that's sort of the beginning of what a voir dire.
And you were before you became a plaintiff lawyer a couple years ago. You had been federal prosecutor.
Federal public defender.
Federal public defender
Yeah.
for 14 years or so.
Yeah, about 10 years. Yeah.
So what you're talking about primarily is criminal federal court.
Yeah, criminal federal court.
Okay. Were there differences when it was in state court?
Well, in San Francisco, I tried a murder case in San Francisco, And no, it wasn't different. It was the same, where everybody could have sat and you asked a question and you strike and replace. So, yeah. The selection process is a little bit different. Each judge has their own selection process, which is unique. But, we'll deal with that later.
Do you have questions that you're asking during voir dire? Like, you come with a set of questions, but I assume. But my question is, then do you branch off depending on what people's reactions are?
Oh, absolutely.
Okay.
I don't come in prepared with questions.
Oh, you don't at all?
I don't.
Okay.
Because I don't think that I'm not the school of thought that thinks like voir dire makes or breaks a case. Mm-hmm. I just don't think it does.
Do some people think that?
I do.
Okay.
I don't think
Good.
it does.
Good. We have two of them.
I think it impacts the case.
It impacts the case, but I don't think it makes or breaks a case.
Well, that's because criminal is different than civil.
Oh, well, then why don't you tell me why you think that it impacts the case?
Well, the bias that you have in criminal, you have to deal with bias as a public defender.
Yeah.
Huge amount of bias. And in the civil case, you do too, but I feel like it's deeper seated.
Yeah, tell me about that.
It's more deeper seated. So I don't think it started off this way, but there's been a lot of propaganda over the decades of, the greedy plaintiff, the ambulance chaser, runaway verdicts, and this kind of dogmatic kind of advertisements in books, in movies, in public thought, which I believe is a campaign by the insurance industry and other big corporate structures. But whatever the reason for that, that's what people come in with. And it's pretty deep-seated, and no one really wants to talk about it when you're called into a civil jury, and that's the first thing. So for you, it's like, oh, there's police, there's jail, this person must be guilty.
Yeah.
For us, it's someone who got hurt, it wasn't intentional, it's someone else's fault, ambulance chaser lawyer, greedy plaintiff, they want a lot of money, and I'm not going to do what they did in the McDonald's case and have my community think that I'm one of those kind of people that would just give that much money for nothing. And it's a very deep-seated set of core beliefs.
And you talk about McDonald's case, you're talking about the coffee that's
the
spilled
first
on the
one.
the
Yeah,
first
the
one.
first one. Now there's been several others.
Yeah.
But there's also a lot of similarities. So,
Yeah.
but you and I come in. This is why I think that there's a symbiotic relationship with public defenders and plaintiff lawyers, because we have to deal with this bias brought by the big bad, maybe good government, but still big, and then we have to explore that. So my questioning is different than his, but yet he and I are very similar, because my best friend Shelley, the way that we describe doing voir dire is you're at a cocktail party and you're just meeting people, some people you know, most people you don't know, and you're just going from person to person or group to group and talking to them. And that works better with a certain type of personality than another.
Yeah.
So that's why for me and Mo, it is, I don't want to say it's easy, because that's disrespectful to how difficult it is, but it comes more naturally. We don't have to gear up for it. We don't have to have, if you go to a cocktail party, do you come in with a script?
No.
But yet we have our points, right? We know that for me as a plaintiff lawyer, I want to know what's the single worst thing about my case? Better talk about that. Got to talk about the elephant in the room.
Yeah.
You don't want to talk about that. Your client has alcoholism issues. You're going to talk about that. Number one.
Get them out in the open.
Yes.
So it's not hidden and it can't look like you were trying to hide
Yes. Number two, credibility. We have to be, that's the number one thing. Am I a credible person? Are you going to trust me? If you think I'm trying to manipulate you, which they all will, they'll think you're trying to manipulate us somehow, because that's what this is all about. The more they think that you're manipulating them, or you're being false, or you're being scripted, or you're not being natural, and you're not engaging, that carries on through, and it will carry on throughout the trial. You want to speak the truth. So it's not just them that's got to speak the truth.
Yeah.
It's you, the lawyer. So if you say something really, really manipulative, you know, let me think. And I don't want to even. I can't even think of them. The defense lawyers do this all the time, but I've seen plaintiff lawyers do this, which is they want to try their case, and so they're trying. But you can't really. You're not supposed to in voir dire talk about your actual case, because you have no right to find out how a jury will rule.
React, yeah.
It's just like when they, when they talk to the Supreme Court justices to see if they'll be fair. They're not supposed to ask them like, "How are you going to rule on this issue?"
Yeah, you can't.
You can't do that.
Yeah.
So,
You can't
but people will go as close as they can, change. And when jurors think that they're trying to manipulate you, then they start withdrawing. So it's really good. Oh, my turn. So it's really good to you can go.
I've had jurors blow up on me.
Because they thought you were manipulating?
Because they thought I was manipulating them. Turned on me.
There you go.
Like
During criminal cases?
Yeah, during a criminal case in a voir dire, they had 8 jurors turn on me. Mm-hmm. That the judge had to excuse them for cause. And what's cause?
Well, we'll get to that in more detail. But they cannot be fair.
They cannot be fair.
Yeah.
And it's a hard standard to meet. Because the judge tries to ask them, now if I give you some rules, are you willing to...
Are you going to be able to stay within?
You're going to stay within?
Yeah.
They were like, no.
Yeah.
And the mistake I made was that it was a very contentious case. It was a case involving immigration fraud. It was right after 2016, after Trump had been elected. And so there was, I always say, oh, I got a hot jury. What do I mean by that? The temperature is running hot. They were just an active voir dire panel. And they were like, you could tell they're fired up. And so they came in and I started to ask them some questions about the facts of my case. And they knew, because they're told, this case involves immigration fraud. And they flipped out. It depends on the rest. I feel like you're manipulating me. I feel like you're trying to divide us politically. I was like, I'm not even doing that. I'm just asking these very simple, direct questions. And then suddenly they were, I asked, does anybody else feel like I'm doing this? And 8 hands went up. And so you don't even realize, but they are watching your every move.
When that happened, did the judge immediately then start questioning them, or
no?
It went on for a while before that happened.
He let me drown.
Yeah. Okay.
He was like, Hamoudi,
let me throw you into the pool.
Man. He was like, go. I ain't digging you out. He's like, go. You did it. You did it yourself, Hamoudi.
You walked through that door.
And then I walked through that door, and I was just like, I couldn't. I was like, my stomach started to turn. I was like,
yeah.
I've had him blowed on me.
So you go in there and you have to, it's not just likability, but being likable and liked is a very good skill set to have in voir dire.
Would you guys think that the differences between criminal and civil is that you're more trying to see how they feel about your client in criminal, and you're more trying to get them to like you in civil?
No, I'm not trying to get them to like me. It's just something that you need to be aware of.
Okay.
And one thing that you can see that Mo and I do you can just see by how when he was talking, but I do exactly the same thing. And I know it because I remember, because people have come, they'll watch me during voir dire and they'll make comments about it, other lawyers. And early on, the comment was, you're smiling almost the entire time. And I am. And I'm not even really aware of it. But again, what did I say that we're at? We're at a cocktail party.
Yeah.
So the energy that we bring, we're very conscious of the energy that you're bringing. You can't just go in there and just be yourself. I mean, you could. But when you're in court, you have to bring extra.
Yeah.
You have to, I've talked about this before. It's not that you're acting and you're somebody else. You have to bring your full self in. So when you're going to a cocktail party, you don't just go there and just sit there and just look at your phone or something. No. You're going in there knowing that you're going to go and interact and exchange energy with other people. And it's this concept of exchanging energy. Like if you go in low energy, you're going to get low energy back. So I go in high energy. Yeah. I am smiling. My eyes are big. I am just, it's completely me, but it's a high energy version of me, and I'm going to get high energy back. So you might not have noticed the kind of energy that you brought there, but I guarantee you it wasn't just the words you said. It was also that you said them with high energy.
Yeah. I did say that. Yeah, yeah. You know, that's harder, Karen. We, you know, with Zoom, what you're talking about, like, I feel like I don't like Zoom voir dire.
I when I first started doing, and we can go into this later, when I first started doing Zoom voir dire, I did not like it either. And now I'm fine with it. I've come to peace with it, and I do, because we can't change the mind.
Okay, well, let's wrap this one up, and we'll start on Zoom.
Was that 20 minutes already? Yeah. Well, let me stop
Wrap it up
by having a, you know, I basically got to the introduction part of it.
Yeah.
We're just at the introduction part. You come in, and there's anywhere, in our cases, typically between 50 and 100 jurors at one sitting. In the big cases, it's very different. You have to do it in groups and panels. But the very first thing that happens, even before you do that, even before you meet the jury now, is that if it's a Zoom jury panel, they'll get a special questionnaire. And if it's a live panel, sometimes they'll get a special questionnaire if the case is big enough, and sometimes they won't. But the judge, number one, is going to find out if there's a hardship. And that will normally get rid of a third of the people there. And what is a hardship? Let's just finish with the hardship.
A hardship is when you have something, it can be anything from a work responsibility to a vacation to a medical emergency or a pre-planned surgery of some sort, stuff like that. So
if you have your tickets for a trip, if you have a scheduled appointment that's, you know, very important, if it will cause a financial hardship, because here a lot of the employers pay for your jury duty, at least a week or two of it, not normally months, and then many people that live from paycheck to paycheck, if it's going to go longer than a week or 2 weeks, that's a problem. In addition, a lot of employers do not pay for jury service, and the person is maybe the sole support, or they really just can't do it. Judges are going to be looking at that one really, really closely, too. They're not going to let off certain people, like a lot of school teachers.
Yeah.
They will not let off the school teachers who come in and say, well, you know, I'm starting a class and I really shouldn't be away from them, which is true. But that's why school districts have backup teachers and teachers, or someone that comes in and says, well, it's not a financial hardship, but I'm the leader of my team at work and my employer really needs me, and they work for Microsoft or Amazon, and the judges are going to be like, they can go find someone else.
Yeah, most of the time they won't.
Yeah, they're very compassionate towards people who will really be hurt and affected, and they're not at all compassionate about people who are self-important or believe that their job is more important than the principles of serving as a juror under our Constitution. So that is pretty much what the judge does at the beginning for hardship. And it normally takes away a third, sometimes a half of the jurors.
Yeah.
Okay. Let's start for the next one.
Okay. Well, that's all for today.
Until next time.